Okay, is everyone here?
Good afternoon, Your Honor.
All right, do we have anyone here on this Texas Young Republican Federation versus Cohen case? Who's here on that case?
Connor, introduce us.
Yes,
no.
you're.
We'll start with who represents the plaintiff.
I do, Your Honor. James Ringle and my partner, Mr. Breimer, is here as well.
Could you spell your name, the second person?
Yes, sir. Brymer.
Okay. All right, and who do we have with the defendants?
Sure. So we have Connor Ellington and Tony McDonald representing defendant Chad Cohen and non-party Young Republicans of Texas.
Okay. Anyone else here on that case? All right, Mr. McDonald, are you here? Are you here on that case?
Yes, sir. Mr. Ellington is my associate. He'll be presenting legal argument today. We may end up representing various parties that are in this case. As of now, we just represent Mr. Cohen and the organization itself, Young Republicans of Texas. But we're going through the process of talking to these folks about whether they want to retain us. So that's just kind of the status of things as of today.
And there's someone here, J.S. Hokar. Ma'am, are you here for this hearing? Ms. Hokar? Mr. McDonald, I can't hear it. You muted. Ms. Hokar, are you here for that hearing?
Yeah, Your Honor, this is Doug Turek. We're here for the Parkland matter that's on the docket, and she's my associate attorney. She may be having trouble with her connection.
Okay. How about Douglas Turek? Is he here for this hearing?
That's me, Your Honor. I'm signed in under 2 because I noticed from a prior hearing you liked sometimes for things to be put up on to be shared, and so those are both me, Your Honor.
No worries. Okay. All righty. We'll go ahead and get started with the TRO and the Texas Young Republican Federation versus Chad Cohen. I don't usually do TROs on the record, but I'll do it on this one because I think it's kind of important. So DC 2318308, counsel, make your appearances.
Thank you, Your Honor. James Ringle for plaintiff, Young Republican, or Texas Young Republican Federation.
Jimmy Breimer for plaintiff, Texas Young Republican Federation.
Connor Ellington for defendant Chad Cohen and non-party Young Republicans of Texas, along with Tony McDonald as well.
And again, Tony McDonald here on behalf of Young Republicans of Texas and Mr. Cohen.
All right. So I will say this, you've kind of picked an interesting judge, or not picked, but you've ended up with an interesting judge. I'm actually former president of the Texas Young Democrats. And when I was elected, there was kind of a similar type of issue that arose, not exactly like this, but so I have some familiarity with this type of issue. So it should be interesting. Why don't we hear from the plaintiffs?
Thank you, Your Honor. Just a little background sort of related to the parties. The Texas Young Republican Federation has been in existence and been using its name continuously in Texas since 1957. As I'm sure the court is aware, many individuals have come through this organization, including some who are currently in the state legislature. And in fact, many of the defendants in this case were also part of plaintiffs' organization. Around approximately early September, mid-September.
Let me ask you this, Mr. Ringle. So is the Texas Young Republican Federation, are they recognized by the Texas Republican Party as the youth arm of the Republican Party, or do they have any type of recognition?
I believe they previously had a relationship, but I would let Mr. Breimer answer that, as he would know more about that. He's also the general counsel for the Texas Young Republican Federation.
So the Republican Party has auxiliary branches, auxiliary clubs. There's not an official youth arm. Our organization, the plaintiff, is recognized by the National Young Republicans. They put out a press release saying as much. So there's not an official youth arm of the Republican Party of Texas. They just have auxiliaries, different clubs that they choose to partner with and not. So we are actually outside of the Republican Party of Texas's reach. Some states have differently, but Texas does not. We are a member of the national organization, but we have legally no connection with the Republican Party of Texas.
So you are the recognized state, Texas, I guess, state organization for the Young Republicans of America.
Yes, sir. They put out a press release denouncing the splinter organization and declaring us to be the true rightful ones. And I've talked with the national council and national board since this has happened.
And is there also, you said an auxiliary, explain exactly how that works in the Republican Party.
So the Republican Party of Texas says, so we're the Republican Party of Texas, but there are other clubs that we are happy to partner with. We'll call them auxiliaries, and it's a whole formal process. Usually takes 3 to 6 months, sometimes years, depends on the organization, whether vetted, aggressively asked questions, brought to SREC meetings, and then they're declared one way or the other by a vote of the SREC. We left.
Is there a youth auxiliary besides the Texas Young Republican Federation?
Not that I'm aware of, no.
And Mr. Ellington, you represent, you said, are non-party, they're called Texas Young Republicans?
Correct. Both Young Republicans.
The Texas Young Republicans.
Just to clarify, Your Honor, I believe Mr. Ellington's client is the Young Republicans of Texas. The Texas Young Republicans is sort of a shorthand for the plaintiff, our client.
Okay, so you're the Young Republicans of Texas. Are you recognized, is your group recognized by the Texas Republican Party as an auxiliary?
That is correct, Your Honor.
Is that correct, Mr. Ringel?
That's our understanding. I believe they are the auxiliary of the Texas.
We were recognized as the auxiliary, Your Honor, but we withdrew because of disagreements with Matt Rinaldi, how he was doing things as the chairman, who he was associating with, including people such as Nick Fuentes, and known Holocaust and antisemitic.
Okay. Mr. Ellington, and so you guys have been recognized as the auxiliary of the Republican Party of Texas. Is that the youth?
Correct. We've been recognized as the official youth auxiliary organization of the Republican Party of Texas. That's correct, Your Honor. My client is.
So I want to make sure I'm understanding this correctly, and please correct me if I'm wrong, because I'm not trying to misconstrue anything, but so the plaintiffs group is recognized by the National Young Republicans organization, and the defense group is recognized by the Texas Republican Party, correct?
That's correct, Your Honor.
Okay.
We would like to point out that the defendant didn't come to existence really till a month and a half ago, or so.
And during that time, you guys have already been recognized as the official auxiliary to the Texas Republican Party?
That's correct, Your Honor.
Okay, interesting. All right, go ahead.
Thank you, Your Honor. So as was mentioned, around middle of September of this year, the defendants had essentially, most of them were members of plaintiffs' organization. They all kind of splintered off into their own group, which they then began calling the Young Republicans of Texas. Once plaintiff figured out what was going on and discovered their use, They, of course, sent out a cease and desist letter attempting to resolve things without having to go through the entire judicial process, trying to keep things streamlined and hopefully just come to a resolution. Obviously, we're here now. That didn't happen. A resolution wasn't reached. As is sort of pointed out throughout the petition, it's our position that the defendants intentionally chose this name to essentially steal the goodwill reputation of plaintiffs' organization and to confuse others such as donors. In fact, Exhibit 3 of our original petition, which is on, I believe, page 38, excuse me, of the PDF, shows then Vice Chair Mr. Colin Pruitt tweeting, announcing that he will be serving as the Vice Chairman of the, quote, new and official Texas Young Republicans. As is evident, sort of even throughout this discussion, that they are not the Texas Young Republicans. I don't think officially they've asserted that position. They're simply trying to piggyback off on my client's name and reputation. And in fact, that Vice Chair, Mr. Pruitt, has since left the organization and rejoined my client's organization due to concerns about some of the anti-Semitism, quite frankly, in the Young Republicans of Texas and amongst their members. And there's that harm to my client's reputation as well, sort of exhibited on Exhibits 5 through 7, where then Secretary of the Young Republicans of Texas was tweeting and liking tweets that seems to have pretty strong anti-Semitic and racist views. And so that's sort of how we all kind of got here. As for the trademark issue, so the Texas Young Republican Federation has a constitution, and sort of it goes over the policies, how different chapters get added in. And one of the requirements in that constitution is that when a chapter joins, they have to acknowledge that the term Young Republican is the intellectual property of plaintiff. And that's on page 19 of the petition, the PDF of the petition, I should say. As mentioned, many of the defendants were either part of a chapter. I believe Mr. Cohen was actually, I believe, a member of the Dallas.
He was the head of the Dallas.
He was the head of the Dallas Young Republicans. And the next page, page 20 of the original petition, shows in the Constitution that once a chapter leaves, they're required to stop using the name Young Republican. Mr. Cohen has continued to use the name, as have all of the defendants, despite being told that it's inappropriate and in a violation of the Constitution, which essentially formed a contract between the chapters and the Federation, because in each of the chapter's own sort of founding documents, they all acknowledge and agree to abide by the Federation's Constitution and the terms therein. So they've breached sort of the contract. They've acknowledged in the past that the term Young Republican is the intellectual property of the plaintiff. The harm is just going to continue here due to the confusion. People have been getting confused. In fact, we just had some right here earlier, confusion with whether or not opposing counsel's non-party client was the Texas Young Republicans or the Young Republicans of Texas. And the affidavits attached to the petition set forth a lot of that confusion as well. The term is trademarked. It's Young Republican and it's owned by the plaintiff. Most of the cases, we admit it's a descriptive mark. We concede that. But aside from the acknowledgement by defendants who were chapters, it has acquired a secondary meaning. It's been in use consistently and continuously for 66 years. Most cases that outline descriptive marks that obtain secondary meaning are marks that are used in 5 to 20 years, or in use for 5 to 20 years. One case had 25 years. 66 years is pretty far out here, and it's pretty obvious based on the affidavits that there is confusion. This is a term that has come to be almost synonymous with the Texas Young Republican Federation. The harm that it would cause my clients to let the Young Republicans of Texas continue using their trademark is just, there's a lot of harm that could continue to happen to the clients, to my client, being tied with these sort of racist and anti-Semitic viewpoints, which they don't agree with, and people getting confused and thinking, oh wait, is that the one that has the racists, or is the other one the one that has the racists, or are they the same group? And the harm to defendants here is really minimal. There's no restriction on any kind of political activity or speech that they could be using here. They can certainly continue calling themselves Republicans. They can fundraise. They can do anything they want except use my client's trademarked name. And in fact, as a note, their own website states that they're not currently accepting donations. So even if they have to change the name, it's not like it would interrupt any sort of donations that they've been receiving or funds coming into their accounts. This would simply be keeping things as they were until such time that the court can decide whether or not this really is a trademark violation and whether a permanent injunction needs to be entered against the defendants. And so for those reasons, Your Honor, we would request that you grant the temporary restraining order.
I'd also like to add briefly, the reason we sued them individually and not as this quote unquote organization was because we couldn't find them at all, registered or anything. And when we did finally get in touch with Mr. McDonald, he claimed was called an uninformed.
Right. So that's part of the confusion here as well on our end, or with our clients and perhaps the public, is allegedly the Young Republicans of Texas are an unincorporated nonprofit association. We haven't been able to confirm that that sort of an association actually exists. There's been nothing filed with the Secretary of State, which are permissive filings, but not mandatory for an association like that. And we did request some kind of proof from their counsel
5 days ago?
Sometime late last week, and we didn't receive any such evidence. So at this time, we're not even really sure if this unincorporated association technically exists. But for those reasons, Your Honor, we would ask for the TRO to be granted.
Response?
Certainly. And good afternoon, Your Honor. So there are 3 reasons why this TRO should be denied. First of all, there is on-point Supreme Court precedent on this subject, and it's clear. Courts are not allowed to restrain speech at the TRO or temporary injunction stage. Secondly, plaintiff's conduct clearly establishes that there's no imminent harm. And third, because plaintiff only chose to sue alleged members of YRT, they cannot prove a probable right to relief sought because they're expressly barred from recovering anything under Texas Business Organizations Code 252.006. So turning to the first point, so with Supreme Court precedent, let me pull the case name. This is going to be Carroll v. President and Commissioners of Princess Anne. What the Supreme Court says is that, let's see, there's a place in our jurisprudence for ex parte issuance without notice of temporary restraining orders of short duration, but there is no place within the area of basic freedoms guaranteed by the First Amendment for such orders where no showing is made that it is impossible to serve or to notify the opposing parties and to give them an opportunity to participate. And even when speech may be enjoined, the court has said that both sides must be present in court to ensure that injunction is issued only when genuinely necessary and is drafted as narrowly as possible. When only one side is heard, the court concluded there is insufficient assurance of balanced analysis and careful conclusions, which are essential in the area of First Amendment adjudication. Accordingly, prior restraints of expression come to this court bearing a heavy presumption against its constitutional validity.
Wait, so Mr. Ellington, You're here. This isn't ex parte,
Um,
right? I mean, you are here, aren't you?
To be clear, Your Honor, if I can jump in, there's several parties that we are working with to see if they will retain us. And so there are a number of ex parte parties. The only party that is present that's a defendant is Mr. Cohen.
Okay. Have the other parties been served?
No.
Your Honor, we did send via email earlier today to most of the other defendants. We didn't have any other sort of quick contact information for the other defendants, but given that, as we understand it, these are all individuals that either are or were.
Mr. Ringel, though, you were notified of this hearing date last week, right?
It was towards the end of last week. I believe it may have even been Friday.
Why didn't you email them as soon as you found out from the court that this was set?
Your Honor, we simply just didn't quite get around to it. And I understand that that's somewhat of a failure on our part, but we also had to collect their contact information and ensure that we could at least send them the notice. We sent them the notice today. I believe it was approximately 3 hours before the hearing, which is even in excess of the local rules requirement of the 2 hours.
Right, but that's usually the intention of that rule is if you request the hearing and the hearing is going to be the same day. But we notified you guys last week about this hearing date. The expectation is that you would notify everybody immediately or as promptly as possible, not wait until the next week, spring it on them. When did you find out, Mr. Ellington, Mr. McDonald?
Well, if I can answer that, I am going to be filing a motion for sanctions against Mr. Ringel on account of his behavior in this case so far. And I'm very reluctant to do that. This will be the first time in my career that I've done that. But quite frankly, I'm outraged by what has gone on. Okay. The suit was filed more than a week, almost 2 weeks ago. We were informed of the suit last week. And at that time, I told Mr. Ringel that we represented Young Republicans of Texas, explained that it is an unincorporated association, explained that because he'd chosen to sue all of these young people, these members, that it would take time on an individual basis to actually consult with him and find out whether they wanted to retain our services. I'd only had that meeting this morning at 9 a.m. because we took a while to organize all these folks. We went ahead and signed Mr. Cohen, who's the organization president, so that we could clearly be here on behalf of a party. We wanted to make sure of that, and we were able to rush that. But these other folks have all need an opportunity to review an engagement letter and all that kind of thing. I told Mr. Ringel, I said, I insist to be informed if there is a TRO hearing in this case, and we were never informed of this hearing. I found out through the counsel for the Republican Party of Texas, sent it to me, and we were able to get a little bit of preparation in. But quite frankly, it's outrageous to me that whenever I demanded to know that there would be a hearing, if there would be a hearing, and Mr. Ringel sat on it all weekend, and quite frankly, we figured it out, over the weekend. But it's incredibly frustrating, and it is a demonstration of the bad faith in this suit. I think this suit is ridiculous and brought entirely in bad faith, and we will address that each in turn. So I will simmer down, but we will handle that by motion. But I wanted to go ahead and inform the court of that.
What kind of makes sense to me, and this is not a ruling yet, but it's kind of where I'm leaning, is that we wait, reset this TRO to next Monday, give you guys a chance to figure out exactly who's the right party here, because it seems like it sounds like, Mr. Ringel, you're not even sure this organization, does the organization exist, Mr. McDonald, or not?
So I specialize over the last 10 years, I've become a specialist in nonprofit organizations, nonprofit compliance. Mr. Ringel doesn't understand that when it's just like a general partnership or a sole proprietorship. You become a sole proprietor when you start doing business. You start a general partnership whenever you form a business with somebody else. You don't have to file anything to become that. Under Texas law, an unincorporated nonprofit association is formed when people organize together. And in fact, you don't incorporate an organization of this nature because Texas has a corporate contribution ban. And so whenever you go to incorporate, you actually tie the hands of a political organization from in-kind contributions and participation with candidates. And so this is the proper course for a political organization of this nature to be an unincorporated association. And thankfully, Texas law makes it incredibly clear that the protections that you would see with a nonprofit corporation are very similar to those in the case of an unincorporated association. And Mr. Ellington is prepared to talk about this for reasons that you should absolutely deny at TRO today, that it is categorically invalid as a proposal. So, I mean, he's prepared to make those legal
Mr.
arguments.
McDonald, let me ask this. You can have this one of two ways. My thought is it would make more sense, I think, for everybody. Not all the parties that need to be here are here yet, and I understand why they aren't. That we reset this the next Monday. What I would suggest is we allow each side maybe to take a deposition in the interim, maybe do some very limited discoveries, because it sounds like there's some misunderstanding between the parties on what exactly is going on. As Mr. Ringgold said, that he wasn't sure if the organization actually exists. So maybe exchange of information on, is there a constitution for this new group? Is there a, what is their affiliation, all that kind of stuff, so that you guys have a little better understanding of what's going on, and reset this to next Monday to give you a chance to do that. Maybe even send you to a mediation. But you can't kind of have your cake and eat it too, Mr. McDonald. If you want to argue the merits on this, then we'll argue the merits. I'm trying to be fair here to both sides. I agree. I don't think really that there was a necessarily good faith attempt to provide notice on this. And I think the parties should all be heard. But you seem to want to kind of you seem pretty confident that you're going to win this. So you can't really have it both ways. If you want to argue the merits, we'll do the merits. If you want to have a chance to get all your ducks in a row and give proper notice and get everybody involved, then I'm happy to reset it to next Monday. What do you prefer, Mr.
Your Honor, I think the appropriate thing is to deny the TRO today. We filed a brief. Mr. Ellington has filed a brief, can argue those points on that brief of why a TRO is categorically disallowed by the U.S. Supreme Court. And then, of course, there would be a hearing on temporary injunction. And we're not opposed to that. But we would like, if we're going to have an evidentiary hearing at some point, we would like that to be appealable. And obviously, we're not going to be able to appeal a TRO. So a delay in the TRO for a week, we might as well just go ahead and get a TI hearing teed up, and we can all deal according to that. But if we're
so just so I can summarize what you said, you want to argue the merits today?
It's categorically not allowed legally. Of course, it's not appealable.
Okay.
So,
Mr. McDonald, you want to argue the merits today? It's a yes or no answer. If you want to argue the merits, you can't have your cake and eat it too. I may agree with you, I may not agree with you, but my understanding of what you're saying is you want to argue the merits and then get your ducks in the row if we have an injunction hearing where you can get all the other defendants on board and figure out what's going on. That's what I understand you're saying. Is that correct?
Yes, Your Honor. We believe you should rule on the TRO today.
You want us to rule on the TRO? Okay, that's fine. Go ahead, Mr. Ellington.
Certainly. So we were at the first Supreme Court case, which is Carroll, 1968. So that dealt in particular with ex parte TROs. But so even outside of that domain, the Supreme Court in 1980 in Vance versus Universal Amusement Co., the Supreme Court struck down a scheme which allowed state courts to preliminarily enjoin alleged obscenity based on a showing of probable success on the merits and without a final determination of obscenity. It held that such injunctions were unconstitutional as they allowed prior restraints of indefinite duration on the exhibition of motion pictures that had not been finally adjudicated to be obscene. It concluded that a state trial judge might be thought more likely than an administrative censor to determine accurately that a work is obscene, but does not change the unconstitutional character of the restraint if it is erroneously entered. the logic of Vance applies to far more than just obscenity, as preliminary injunctions, no matter what speech is being enjoined, rests not on a court's final determination that the speech is unprotected, but on a mere finding of a likelihood that speech is unprotected. Because plaintiffs requested TRO as a prior restraint of expression and association, and the Supreme Court has expressly disallowed such TROs in Carroll, the application for TRO must fail. Even then, speech may not be restrained until final judicial determination that it is not protected by the First Amendment. Injunction ordering defendants, many of them members of a group of young Republicans officially recognized by the state Republican Party, to cease referring to themselves as young Republicans would be an injunction restraining speech. Because a temporary injunction restraining speech is a prior restraint, it would violate the First Amendment to grant that as well. So, on the second point, plaintiff's conduct itself establishes that there is no imminent harm. So their cease and desist letter was filed back in September 22nd. And so a month afterwards, they file suit. And then, so that's going to be the 23rd of October. We're now 2 weeks out from that. And only today they filed a draft temporary restraining order for this court. So the appellate court, the Fifth Court of Appeals in Dallas, has found that, it is noted that time elapsed between the filing of the emergency motion and entry of it, or attempts at entry, undermine the need for immediacy, which is a required element of issuing a temporary restraining order. There, in that case, a week passed before a proposed order was submitted to the court. Here, 2 weeks have passed, and the proposed order was only filed today at 2 or 3 o'clock. If injury was truly immediate, why is plaintiff seeking an injunction 2 weeks after the filing of their emergency motion? Furthermore, why wait months to file suit? The answer is clear. There's no immediate injury. This court should deny plaintiff's motion. And then on the third point, because plaintiff has only sued alleged members of YRT, they can't prove a probable right to the relief sought, which is a required element, because they're expressly barred from recovering anything under Texas Business Organization Code 252.006. So that section of the business code deals with unincorporated nonprofit associations. So, and this is filed with the court, but and we quote directly from it, Texas Business Organization Code 252.006 states that a nonprofit association is a legal entity separate from its members for the purposes of determining and enforcing rights, duties, and liabilities in contract and tort. If you look at all the causes of action in their original petition, it's breach of contract and it's tort claims. Young Republicans of Texas is a separate entity from its members. They've only sued the members. The law further states that a person is not liable for a breach of a nonprofit association's contract or for a tortious act or omission for which a nonprofit association is liable merely because the person is a member, is authorized to participate in the management of the affairs of the nonprofit association, or is a person considered as a member by the nonprofit association. And additionally, the law states that a tortious act or omission of a member or other person for which a nonprofit association is liable is not imputed to a person merely because the person is a member of the nonprofit association, is authorized to participate in the management of the affairs of the nonprofit association, or is a person considered as a member by the nonprofit association.
Let me ask this, because I think this is important. So Mr. Cohen is the president. Who has actually been posting or using this name of the Texas Young Republicans?
Your Honor, it's the Young Republicans of Texas. It's not the name of the Texas Young Republicans.
Young Republicans of Texas, I'm sorry. Who's been using that name? Is it all of the people that have been sued or just Mr. Cohen?
Well, Your Honor, there are people who are named defendants in this lawsuit who are not currently associated with the Young Republicans of Texas. There are other named defendants who are members of the organization, but I couldn't tell you off the top of my head.
I'll jump in and also add in. I don't know which of these defendants have actually even said, I'm with the Young Republicans of Texas. I would assume that Mr. Cohen has, as the president, obviously. But beyond that, the allegations in the petition are not clear. They're not individual specific.
Attached to the TRO, there's some, I think, postings online or something about we're now the official arm of the Republican Party or something. Who did that post? Was that Cohen or somebody else?
That was not Cohen.
If I recall correctly, that's Pruitt, who isn't sued and isn't part of the organization. But I'm still piecing it together who all these folks are myself. But obviously the party has put out things saying these are our recognized officials.
The Texas Republican Party has put out.
Correct. I mean, they passed a resolution at the SREC meeting a month ago.
If I may, Your Honor. So yes, the tweet about them being the official Young Republicans was Mr. Colin Pruitt, who is not a named defendant because he afterwards left the defendants, the Young Republicans of Texas, and returned back to the Texas Young Republican Federation. And then there are some other social media things that are shared by an individual named Noah Coffey, and he is a named defendant. He was, at the time that we prepared to file the suit, he was, and shortly beforehand, he was I believe the secretary of the organization. Defendant Ashley Leathers is one of the board members, I believe the treasurer of the organization. And Heath Bell, who is also a named defendant, is the vice chair, the new vice chair of the Young Republicans of Texas.
All the people listed have made it known to our organization, either publicly or told us, that they are taking their clubs and they're leaving and they're joining the Young Republicans of Texas as opposed to the Texas Young Republicans, and that's why they're all listed. We did ask Mr. McDonald for proof of his organization, bank account, anything like that, and anything from it. If we get that,
it's very hard to hear you, sir, because you're not close to the mic.
Sorry, sir. Sorry, Judge. All the people named are people that have declared on social media or told the person that are listed on the website that they are part of this organization. We asked Mr. McDonald last week for proof of this organization, bank account, anything like that. Constitution, like you said, we didn't receive anything. So that's why we proceeded this way. If we received proof that before this lawsuit was filed, they did enter into that organization, unaffiliated, what have you, then we will happily change the name.
And I guess that goes to your point earlier, Your Honor, as well, regarding, the depositions or limited discovery. I mean, we attempted to gain clarification from Mr. McDonald. We had emails back and forth, and he mentioned that they were an unincorporated nonprofit association. I requested evidence of that and have not received anything. And so at this point, that's part of why we're sort of contesting the existence of it. We just don't see that there's any proof on that. We'd also point out, Your Honor, that this case is easily distinguished from the cases that defendant points to in their brief. As to the Carroll case, in that case, they were seeking to enjoin groups from holding a political rally. Here, we're not seeking to enjoin any kind of activity by the defendants except using our client's trademarked name. Similarly, it's distinguishable from Vance. In Vance, there were alternative paths. As mentioned, there were administrative censors to determine obscenity. Here, the court is really the only path to protect the trademark. There's not really another option. I mean, it's easily distinguishable. And on top of that, Your Honor, if nothing else, most, if not all of these defendants contracted away that right essentially to use the name Young Republicans. It's in the Constitution of the Texas Young Republican Federation that says, it is the intellectual property of the Federation, and you have to stop using it if you leave the Federation. And they agreed. They were part of the Federation at one point. They agreed to these terms per their own charters.
We don't agree.
Donald, you were going to say something?
I just wanted to correct, I'm sorry to interject, that we don't agree that these individuals were members of the organization. I mean, there's going to be a number of issues in defense in this case that just aren't really right for this stage, but why they have sued these
I could
individuals.
have sworn maybe the judge thought you might want to reset this for a week, but you declined. So I really have tried to give you a chance to get all the ducks in a row. I do feel like I'm shooting in the dark a little bit here.
Well, and that goes to the issue. If you're shooting in the dark, then you should deny the TRO, because, I mean, again, if you look to the TRO doesn't, the proposed TRO has no specificity. What is the imminent irreparable harm? What precisely do they want these people to do? It would be void if signed, Your Honor, because it is not adequate for a TRO, even outside of the First Amendment context. The problem we have here is that they are asking you to tell a group of people who are officially affiliated with the Republican Party of Texas, a group of young people, a group of young Republicans, that you cannot call yourself young Republicans. That is obviously an infringement on their First Amendment rights, the rights of the party.
You don't have, the First Amendment's not absolute. We learned that in your first year of law school. And so, you're saying I'm kind of shooting in the dark, and I agree I'm shooting in the dark because I don't really feel like there's been enough discovery done. I do think that I am concerned about the fact that there is this provision within the Constitution of the old group, I'll call it the old group and the new group, or the old group that says you can't leave. I just don't know. Is there any proof in what you've submitted that Mr. Cohen was a member of the old group at one point?
He freely admits that he was the Dallas County YR. He sent a Dallas County YR chapter chair. He sent us we actually kicked him out of the organization because he wasn't doing anything for the past 2 years, and sent him notice of that. Matt Dorsey also was in charge of the Rock Wall YRs. Various other groups tried to join, but they had various anti-Semites in the organization. Told them no.
None of this is before the court, Your Honor. And that's the issue here. At this stage, with the issuance of an ex parte TRO, they have not met their burden to show imminent irreparable harm, to show probable right to relief. And so the correct ruling for the court is to deny the TRO. Now, granted, if you want to set a TI hearing as ASAP, that's great, but we really would want we want a TI hearing, because if we have an injunction issued, we want to be able to appeal it. And so just to be clear on that and seek emergency relief. TRO doesn't offer our one client and potential clients a right to seek relief from that order.
And let me just make it clear, just because I probably haven't said this in my mind. I thought I made it clear, but maybe haven't. The only person I'm considering a TRO against at this point is Mr. Cohen. I'm not going to issue a TRO against the Texas, the old group, the new group, against the new group, or any of the other parties, because they were just served and are not here. And so the only person I'm considering it at all is Mr. Cohen. I'm telling you what I think would make sense here is, given the kind of unusual political situation, is if the new group, this is not a ruling, this is just what I think makes sense, is if the new group would provide a disclaimer on all their materials that they're not the Young Republicans of Texas, Texas Young Republican Federation, and that they're not, they're recognized as an auxiliary to the Texas Young Republic, to the Republican Party, but not recognized by the Young Republicans of America, something like that. That to me would deal with, I think, most of the issues in this case. I would want to also see some briefing about descriptive marks. Is this something you can contract away? I've never seen that done quite in that way. I actually had a case that's somewhat similar this summer between the Bad Girls Biker Club of Texas, or Bad Boys Biker Club Dallas and the Bad Girls Biker Clubs of Dallas on a very similar issue about was it an was there a trademark violation? And I can see how people could be confused given the similarity of the names. So I think, what makes sense, not a ruling at this point, would be, and I'm trying to get to a resolution for you, would be, I think you guys need to figure out more about this, each other's positions, how these organizations are structured, do some limited discovery. Hesitant to grant a TRO against Mr. Cohen. He's the president of the new group. Does anyone research the idea that do this with a disclaimer? Has anyone looked at that issue?
Well, Your Honor, sorry, I'll let Mr. Ringgold answer.
Briefly, Your Honor, I know that some cases have previously resolved in that fashion where a party, simply issues a disclaimer on all of their products, merchandising, signs, etc. And again, that was part of, certainly one of the options that my client was willing to explore prior to filing, hence the delay from sending the cease and desist to filing the lawsuit. They were willing to explore alternative options.
Your Honor, I would just go back to this. The relief requested today is not some kind of specific relief such as you've requested or you've explained. So that's not being requested from the court in this TRO motion. That's something that could be asked for, but I would again go back. I would like to have this be brought up in a temporary injunction hearing posture where we could have an actual evidentiary hearing. I would like to bring the Republican Party of Texas as with evidence from them. Basically the party is going to assert they have a right to recognize a youth auxiliary, and they predate TYRF, right? The Federation. So there's an issue there that's kind of critical.
Mr. McDonald, I absolutely agree with you on that point. That I think before the injunction phase, what I'm struggling with is, do I grant a TRO just against Cohen in the interim? What I'm going to do, what I'm going to do at this point is I'm going to grant a TRO against Cohen, saying that he is not allowed to publicize the Young Republicans of Texas, or whatever the name is, the new name, without a disclaimer. So if he's going to do any type of publicity, use this mark in any way, he has to have a disclaimer to say that they are not the Young Republicans, the Texas Young Republican Federation, and that he can put that they're an auxiliary of the Texas Republican Party, but they are not recognized by the Young Republicans. That needs to go on anything that he puts out between now and the time of the temporary injunction. Now, all the other defendants are not restrained, obviously not the new group either. And then let's go ahead and get a temporary injunction hearing set. Would you all rather do that in person or remotely? I know people are kind of all over the state. So, and let me tell you how I do this in my court. On Mondays, our hearings are completely remote. On Fridays, we allow it to be in person, hybrid, or on Zoom. So if you wanted to be here in person, I don't know where you guys are all located. And you wanted some people to be in person, you could. If some people want to appear remotely, we have some brand new technology that's pretty effective with that. So would you rather do this first off on a Monday or a Friday?
Your Honor, we're all actually within about 45 minutes of each other. They're in Leander, we're in Bastrop, and Mr. Ringel and I also live in Austin. So
we'd prefer an in-person hearing on Friday. If Mr.
Not this
McDonald-
Friday, but
yes,
Sure,
Friday.
the following.
Mr. McDonald, what is your preference?
I would prefer an in-person hearing in Dallas. The Friday of the 17th, I have a conflict. I don't know if you're proposing to do it that quickly.
That's the only date I can do, unfortunately, unless you guys agree to extend the TRO, because I have to do it within 14 days, and that's the only Friday I can do. But I'm happy to, if you're willing to extend it by agreement, I'm happy to do it at some other day. I'm not going to do it the week of Thanksgiving, obviously, but I could do it the next Friday.
Well, I'm thinking we could. thinking it would be better. We really just have to actually get these clients signed. We don't even have that going yet.
Right.
So we could agree to a 14-day to a 28-day. I guess that would cover us to get us to December 1st. If December 1st is
I'm
available.
sorry, I can't pull up my calendar. Is that a Friday?
That's a Friday, December 1st.
Mr. Ringel, what are your thoughts on that?
We're in agreement with that. That would be just fine.
All right, so let me make it clear, Mr. Ringel, you're going to be putting together the order. I hope you understand what the order is that Cohen is required for any post he makes for the Texas Republican, his Young Republicans of Texas, that there's a disclaimer on it that I just stated. In the interim, also, I'm going to require you guys to be able to take one deposition per side. So you could take one deposition of them of up to 2 hours. The other side could take a deposition as well. So each side can do one, unless you want to do two. Do you prefer two or one deposition, Mr. Ringel?
I think we would prefer to, but one should certainly be sufficient, I think, to get to what we need.
Mr. McDonald, what do you think? Do you want one or two?
The minimum, we would object to
Okay, so
any discovery. So if it's one, that's better than two.
One deposition per side. It can be by Zoom, and it'll be up to 2 hours. I'm going to allow you each to send out 3 requests for production and 3 interrogatories that have to be answered within 7 days. And then we're going to pick a mediator. Neither of you guys are from Dallas. Would you rather, what kind of mediator would you want? I'm thinking of, you want somebody who's more political, who understands the politics of this. Like there's a guy here in town, I don't know if you know him, named Charlie Sarton. I'm not sure he would mediate this, but he's very knowledgeable about election law. He's a Republican. There's Maxine Aronson, who's mediated. She's been involved in a lot of nonprofit stuff. She's a Republican precinct chair, I think, or she was. Or would you rather just what kind of mediator do you want?
Well, Your Honor, I would just ask the court. We're at a TRO hearing with a couple days notice here. It would be preferred if we could have time to actually answer the suit, and there's some special exceptions that are issued. There's a ton of issues that need to be addressed with the court.
Mr. McDonald,
so I'm not opposed to early mediation, but this is very, very early mediation. And
let me tell you how I do this. This is not treating you any differently than most of the TROs I handle, which is I'm going to order you to a mediation before the temporary injunction hearing. So and I don't mind if you move the temporary injunction hearing back to be able to conduct mediation, but you're going to need to conduct mediation. So I'm trying to get some input from you on what kind of mediator, what kind of background would you want? Do you want somebody with a political background or just somebody with a business background?
I'd prefer somebody who's an experienced litigator, just, more of a regular practitioner. That'd be my preference.
Do you care about, and I wouldn't normally ask this, but just given your nature of this case, would you prefer somebody with a political affiliation or not?
I'm indifferent on that. But I would prefer somebody who's a good experienced litigator, more so, and maybe even in the IP area than being political law.
And I think, Your Honor, we would probably prefer someone who's got sort of some IP or business. I mean, in an ideal world, I suppose they'd have all three, and political knowledge of some kind. Just so that they have.
So with IP experience, that's a little out of what I deal with. Do you have a suggestion on who you want to use, either side?
Yeah, I think he would be best for everyone if you picked it properly. You picked the mediator. Okay,
give me a minute. I'm going to go grab my list and kind of look through it and see what about he's kind of expensive. I don't know how much you want to spend on this, but he'd be perfect for this. Would be Jeff Kaplan, former magistrate judge, but he's very expensive.
Well, what do you mean by expensive, Your Honor?
Probably $2,000 a day.
Yeah, that's a bit, I mean, is there anybody that's less? I feel like my experience, it's been, $800 for a half day or something like that.
Yeah, let me go grab my list, see if I can find someone cheaper. I'll be right back. Let me see what I can find. John Darren Klumchuk. I don't know how much he charges, but he specializes in IP. You want me to call and see what his rates are?
That would be fine with me, Your Honor.
That'd be great, Ron.
Even all Darren Klumchuk. Either side.
We don't have any objections to that.
All right, let me see. Yeah, this is Judge Hoffman in the 68th District Court. I was wondering if Darren was around. We have a mediation question for him. Okay, thank you so much. This is Judge Hoffman in the 68th District Court. Thank you so much. Yes. I'm in the middle of a hearing right now, and we're trying to figure out, do you know what he charges for a half day of mediation? Yeah, as soon as possible. Yeah, it's you can give him my cell number, because we're literally in the middle of the hearing. We're trying to figure out a mediator for this case. It's 214. I know. That's a good point. Yeah. Yeah, if he could call me right now, that'd be great. Right, thanks. So Mr. Klemchuk, he's kind of, he does more hard IP, but he would be extremely qualified for this. What about Rick Faulkner? Do you guys know him?
I don't believe so, Your Honor.
He's very involved in the Republican Party, and his wife is actually a Democratic judge here. He's done a lot of arbitrations, mediations, that kind of stuff. very experienced. But I don't know how much IP he does. That's not really his area.
I don't know that I'm particularly hung up on the IP thing. If you have a good referral, we'll take a good referral. I think my main concern would be that we don't have the fee doesn't end up being 11x.
No, I get that. Well, I'm Clemcheck, I imagine, is going to be very expensive because you wanted someone who's a really active litigator. He's an excellent, from what I understand, excellent intellectual property litigator. But I can call Mr. Faulkner and see what he says. I don't have any idea what his fee is. Hey, Gina, this is Martin. Are you with Rick? Oh, I'm trying to reach him. I don't think I have the right number for him about a very unusual mediation. And so I thought it might be perfect for him. Is he there or no? Okay, what's his number? Okay. Okay. All right, this is an interesting one. He'll enjoy it if it works out. So yeah. Thanks. Bye-bye. Hey, Rick, this is Judge Hoffman. Good. I'm in the middle of a hearing right now. You're actually on YouTube and Zoom right now, so I just want to let you know. And it's a very unusual case that I thought would maybe be up your alley. But first off, what do you typically charge for a half-day mediation? It is kind of an issue for them. So 750 aside. Okay, yeah, I think that'll work. Let me put you on speaker. Rick, are you there?
I'm here.
All right, so they charge this is Rick Faulkner. He's a very well-known arbitrator and mediator here in town, and also been this case involves a lawsuit between the Texas Young Republican Federation and some of its former members, and about an alleged trademark violation. And I want to get this mediated before they basically started a new group, and one of the groups is recognized by the Texas Republican Party, and the other one's recognized by the Young Republicans of America. So there's a dispute.
Okay, I've done trademark work, I do IT work.
Oh, good, good. Did you guys hear that?
We did not.
I believe he said he's done trademark work. That's great.
Needed, trademark cases, I think if you run my name, you'll find, one or two of them may have made trademark reporter years ago.
Okay, so he's done a good bit of trademark work, and he's also done a lot of political stuff with the Republican Party. I think he'd be perfect. He's only $1,500 to be split between the two sides for a half day. So I think that's a little more affordable than what we were talking about. Does that sound okay to both sides? The other gentleman, Mr. Klemchuk, is calling right now. Do you want to go with Faulkner, or do you want me to try to talk to Klemchuk?
Well, that sounds fine to me. The 750 sounds completely reasonable.
That's very fair.
Yes, Your Honor, we'd happily agree to that, to Mr. Faulkner, being mediator.
We reviewed.
I think it's kind of the perfect mix of what you wanted. So, Rick, what is the best way for them to reach out to you?
Oh, here, I just give both lawyers my mobile number, that's what this is.
Okay. The phone number, his phone, or do you want him to email you too, or no?
Yeah, why don't they email me is R. Faulkner,
Or
F-A-U-L, Faulkner, F-A-U-L-K-N-E-R. Law.com.
did you get that?
We only got the R. Faulkner portion.
R. Faulkner at Faulkner Law ADR, sorry, FaulknerADRlaw.com, correct? And his cell number is, I'm on. Okay, I'm not going to put it on YouTube, but I'll take it off of YouTube and tell you guys once this is over. But
Yeah, well, those people I was a judge in their cases years ago.
yeah, so I don't want to give that out. But Rick, we need to get this mediated before the temporary injunction. The temporary injunction is currently set for December 1st. What? Oh, I don't think they're ready that quickly, but they need to do it before December 1st. Unless they move the injunction. Okay, Rick. Thank you, Rick. We appreciate it. All right, bye-bye. All right, I think this is kind of perfect for this case. He's kind of perfect for this case. So, all right, any questions?
I just wanted to clarify if you can instruct that the order be circulated for form.
Yes.
I think you keep saying National Young Republicans, National, or I can't remember what you've called them, but I think we're all going to be able to agree if we work together on what the correct terminology is.
Right, you use the correct terminology. I do not know the correct terminology, so use the correct terminology on exactly whatever, because the Young Democrats of America, I think, are called the Young Democrats of America. Or is that not what the Young Republicans of America are called? Or
National Young Republicans Federation
National Young Republicans. Okay, so
would be
different.
what I think they're referring to.
Yeah, so that name, whatever that name is, but make sure it's correct. So, Mr. Ringel, you're going to prepare an order on this TRO, as well as on expedited discovery. We'll do a mediation order for you. And you're going to share that with Mr. McDonald. Mr. McDonald, you're going to have 8 hours, 8 business hours to review it and get back with any comments or changes. And then, Mr. Ringel, you're going to need to get me this order no later than this Friday.
That's extremely fair, Your Honor.
Understood, Your Honor, we can have that done.
And the temporary injunction, do we set a time on December 1st? Do we say 9?
We haven't talked about a time.
Yeah, so let's do 9 o'clock. And then we also need to set a bond. I think it should be de minimis, but I'm happy to hear what the argument is.
Mr. Ellington, I told you to prepare on this, so if you can address it.
Sure. So we think the bond should be substantial. As the Supreme Court has noted in Elrod v. Burns, the loss of First Amendment freedoms, even for minimal periods of time, unquestionably constitutes irreparable injury.
Mr. Ellington, no, I haven't prevented him from speech. He just has to do a disclaimer. So So let's talk about what that would really be.
So
Are they fundraising, or what are they doing right now? Are they not? I understand that they weren't fundraising.
I'm not sure about that exactly, but whether they're fundraising or not, forcing Mr. Cohen to have to speak, that would be a form of compelled speech, and so it's still a violation of his First Amendment rights. And Supreme Court precedent has said that that it's irreparable injury.
Mr. McDonald, give me a suggestion on a bond.
I would say $1,000 at least.
Mr. Ringel, what do you think?
I mean, we would suggest a bond of $100, as the court noted. I mean, there's not any real restrictions on speech here. It's essentially just saying use a disclaimer, clarifying that you're not part of this other completely separate organization. And they're not even, as far as I know, they're not even fundraising or taking donations right now. Their website says that they're not taking donations. So
about 20 minutes.
I'm gonna require a $250 bond. Okay. All right. Anything else? And anything else we need to cover today?
I don't believe so, Your Honor.
All right, guys.
Your
I enjoyed this. I look forward to seeing you guys on December 1st. If the case settles, please let me know. I encourage you guys to try to work it out. And I want to make this clear. This is only applying to Mr. Cohen, not to any other parties. So I don't want you to add in any other parties.
Understood, Your Honor. Yes, it will strictly be for Mr. Cohen.
You guys have a great rest of your day, okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right, I believe I have a hearing in the Dallas County Hospital District versus Goldwire case.
Yes, good afternoon, Your Honor.
Both sides here for that?
Your Honor, Douglas Turek and my associate attorney, Jesleen Jakar, are on. I'm not sure who else is on for the hearing.
So Ms. Tremaine, is she still involved in this case, or Mr. Ferry or Mr. Jeffries?
Your Honor, they are, and we did send out a notice of hearing. However, because this is a motion for substituted service, it does not involve their clients. So I'm assuming they elected not to attend, but they did receive notice.
All right. So I just had questions about the subsurface on this. It was a little complicated. So I just wanted to chat with you. I'm glad Odyssey's back up. This is going to make it easier. So you're trying to do a subservice for 10 different defendants at the same time?
Unfortunately, Your Honor, it's 12 defendants.
Oh, I'm sorry.
Yeah, so we have a total of 24 defendants in the case. These they're all nurses that participated in the Parkland nurse residency program. And so a lot of nurses across the country now are traveling nurses. They're nurses that have a permanent residence, but they're serving most of the time out of state or out of location. And I think that's a situation we have here, which is why it's such a low successful service rate in this case.
Okay. So it looks like for Lindsay Brady, Stephanie Brewer, Penny Hargrove, Alicia Dodds, and Craig Balfour, that you were unable to confirm an address. Is that correct?
Yes, Your Honor. We were not able to confirm an address through through a verbal confirmation with either the resident, the person at the residence, or a neighbor. I believe on those there were some issues with maybe identifying their vehicle and or the public record search, but we were not able to get a verbal confirmation.
Okay. What kind of confirmation did you get let's start with Lindsay Brady.
Okay, let's look at Brady. So, and I apologize, Your Honor, like you said, it was a little complicated, so if you'll bear with me while I get to that.
No problem. No problem. I understand.
So Brady is, so for Brady, we were able to do, so there were 4 attempts made at service. First attempt, there was no answer. Second attempt, there was an individual, but the process server was able to tell there was someone on the other side of the door, but they did not answer. Third and fourth attempt, there was no answer at the door. We do have public records through a people search that this is the address is confirmed that was attempted for service. So on that one, there was no verbal confirmation or tying vehicles to the defendant.
What about, don't you have an email for all these people?
We have old email addresses. Some of these, unfortunately, when we get them at our level of escalation for litigation, it can be 2 or 3 years out. So we do have old addresses that are in the original file, Your Honor.
Okay. All right, you're gonna need to serve her at that address and with at her most recent email you have.
Okay, so Brady, most recent email and the address in the motion.
So posting or, person over the age of 16 and by email at the most recent email address you have. All right,
Understood.
what about Stephanie Brewer?
Stephanie Brewer, first attempt, no answer. Second attempt, no answer. There was a text received from the defendant Brewer after a business card was left on one of the attempts, and she confirmed in the text that she lived at the address, but that she was going out of town.
So that's all you need to do is post for her. You don't need to do an email.
Yes, Your Honor.
All right, so what's Hargrove is the next one.
Okay, let's go through Hargrove. So Hargrove, we have first and second attempt, there were no answers. Third attempt, there was no answer from the address, but a neighbor stated that they had not seen anyone at the address in a while. Fourth attempt, no one answered. And then the public records on this one indicate that she lives at the address. So we were not able to confirm either verbally or through vehicles at the location.
So you'll need to serve her via email and posting.
Yes, Your Honor. And I'm sorry, that's
that was Penny Hargrove.
okay.
Then we have Dodd, Elisa Dodd.
Yes. So Miss Dodd's first, second attempts. This is a location that has a call box. Requires an electronic key fob to get in, so they couldn't actually get to the unit itself. So that we were never able to get anyone from the unit to respond to the access attempts. This is one again with public records is really the only confirmation that we have.
All right, by email and by post, and well, shoot, for that one, can you even post? Is there a place how do you anticipate? Is there?
So there is a potentially there is a management office that it could be left with.
Were they able to get to the management office?
I believe so. Let me look at the actual underlying affidavit and make sure.
Oh, Tony, you can go home.
Get to the affidavit. That's Exhibit U. Okay. Yeah, so there was contact made with the management office, a leasing consultant named Aaron, but they have an internal policy where they cannot disclose residents. So they were not able to confirm or deny the residents.
All right, unfortunately, that one I'm gonna need to deny at this point, and you just need to
Okay.
get information.
All right, we'll come back with a solution. I don't know the exact situation, but as soon as we can get it figured out, we'll propose the most probable way of getting it served.
Yeah, maybe social media. I mean, this one sounds like a little more difficult. So, Craig Balfour.
Yeah, so Balfour, Your Honor. Yeah, left the business card first attempt, no answer. Property manager on the third attempt stated they were unable to verify. And so that's one also that the leasing office was not able to confirm or deny. Let me just see if there's anything that might make that one different.
Well, it sounds like, were they able to get to the person, to the house, to the apartment, or no?
No, they were not. This one needs a badge, and so this is much like the Dodds
Right,
situation, Your Honor.
Those two are denied for now, but the other three. So if you could, which I don't have the orders in front of me. Did you do this as an omnibus order or separately for each one?
I did it as an omnibus, Your Honor, and I can update these specific defendants with the additional required
Yeah, so
service.
do you want me to sign it for the ones that we granted?
That would be great from a timing standpoint, Your Honor. If you could just, we listed out the defendants 1 through 12 with the address attached to them.
Yeah,
So
I'll take out for now Lindsay, Brady, Stephanie Brewer, what her name? Stephanie Brewer, Penny Hargrove, Alicia Dodds, and Craig Belfour.
And Your Honor, I may have written this down incorrectly, but we had discussed Brewer. I thought that that was one that
Brewer,
we could.
you're right. Brewer's okay.
Okay, all right. Just wanted to make sure.
Correct. You're absolutely correct. All right. So you're going to get me an order for Brady and Hargrove that indicates they're by email, and for Dodds and Balfour, you're just going to do a little bit more research.
Yes, Your Honor. We'll file a new motion for subservice on those two specifically.
Okay. All right. Sorry to kind of give you a hard time on this, but we just want to make sure we're doing it right. So
I'd rather get it right. This is important for everybody.
all right. Thank you so much, and have a great. Anything else we need to chat about?
No, Your Honor. Thank you.
All right. Thank you, and have a pleasant evening. Okay.
You too. Thank you for your time today.
No problem. Bye bye.
Bye.